And we'll get started basically with an intro to me. So I'm Nick. I recognise lots of names and faces, but I head the employment team at Actons. For those that don't know me or our team, we work based out of office in Nottingham, and we work with clients across the East Midlands and beyond. And yeah, we're getting muted. That's excellent. We work with clients across the East Midlands and beyond, some of which you'll have heard of and are on the call today and listed on that slide, some of which are fantastic SMEs, more local to us. We cover the full range of employment law, from contracts and handbooks and policies and all that fun stuff, through to TUPE transfers and business acquisitions and all that kind of thing, or even further down to the other end of the spectrum, the messy stuff like absence management, or situations where one of your managers has punched a customer or had a relationship with a colleague and it's gone wrong and everybody's fallen out, or that kind of messy end of employment law as I describe it. We have a fabulous team, two of which you will hear from later in the session. James and Laura will be presenting along with me today as well. And we will get started on that note. As we go, really happy to answer any questions. We'll do that via the chat. So again, feel free to pop any feedback or questions in there as we go. And there'll be some resources, as Matt has kindly put the HRD Talks link in there, for example. We'll pop a few bits and pieces in there as we go that hopefully will be useful resources for you as well. But yeah, feel free to keep it as interactive as possible. We've got a few suggestions around the next webinar, which is great. So on to today, you might have noticed that we're due a general election pretty soon. In fact, on the 4th of July, so not too far away at all. We're very happy to be hosting the leaders in Nottingham this evening. In fact, we hadn't planned that, but they will be at one of our universities debating it out. No doubt it'll be an entertaining affair. Yeah, we're really pleased to be talking about some of the stuff that might be coming should we have a change of government. And I guess we have focused this entirely, I was going to say predominantly, but entirely on what Labour might do should they win the election. And that's on the basis that most of the polls, if not all the polls, are predicting a Labour win. We are not supporting Labour in any way. We're going to keep our political affiliations very close to our chest. But it's pretty clear that the polls are suggesting that Labour will win on the 4th of July. And in fact, on the slide there, you can see that I think it was the BBC have kind of compiled all of those polls and rated the support that each party has. We obviously had quite a long period of Conservative party governance and a number of prime ministers during that time. Again, we're not going to comment on that, but there has been a pretty steady period of time where a Conservative government has been legislating in a certain way when it comes to employment law. And we think that's likely to change. And therefore, we've been scouring all that we can find in terms of detail. And to be completely honest with you, there's not lots, but scouring as much as we can find to try and look at what might be coming should we have a change of government. And there is some headline principles that we can look at, some key proposals. And we're going to look at some of those today. I think the other thing to remember is, for those of you that are old enough, Laura won't be old enough. I'm certainly old enough, and James is somewhere in the middle, I suspect. A Labour government previously did take quite a different approach to employment law. And for example, the last Labour government we had introduced the national minimum wage. So actually a pretty significant part of what we've kind of become used to, but does create a certain environment for employees and employers in terms of pay. And we think actually there could be some pretty significant changes coming. How quickly they'll come, we'll see, but they could be pretty significant in terms of that change of government. This chap here is a consultant that we're using to help us prepare for the webinar, and he can't really work out exactly what's going to happen either. So we're kind of reassured by that. But we do have some detail, even though we are crystal ball gazing a little bit. We have a number of different areas where Labour have put detail out on this, and they're talking about certain things, but essentially we're looking at things like this New Deal that they're talking about. And again, the slide sets out some of the places that you are able to find what the proposals are, and what detail is out there is contained within these documents. And that's essentially the New Deal plan and the Labour Party manifesto. And again, hopefully links to those are going to appear in the chat for you. Thank you, Sean. And again, they're pretty wide-ranging in terms of the different areas that they cover. So we're looking at things like zero-hours contracts, which again, Labour has been very anti those kind of contracts because they think they exploit workers. They're looking at things like fire and rehire, or fire and replace, as it's been referred to as well, where people are just fired and not rehired, just replaced with other types of workers. Understandably, they're also looking at the role of the trade unions and their kind of role in the workplace, and of course also looking at enhancing workers' rights just generally. And I think that you'll get the gist of that as we go. They're also looking at the timeline for this, and the headline grabbing sort of suggestion has been that they'll introduce legislation within 100 days of taking power. And by our calculations, that's the 12th of October. Now, we'll talk a bit more about how that might work, but we think in the main, that probably is headline grabbing as opposed to realistic. That said, excuse me, we think the first session of Parliament is likely to include an employment rights bill, so some legislation that they would like to take through Parliament, House of Commons, House of Lords, and the interesting thing will be what that actually contains. So what they prioritise as the kind of the key stuff that they want to move through quickly. Some of this stuff, and we're not going to go into crazy detail on the way in which laws are made, but some of this stuff they might actually have the power to change already. Some of it will need new legislation. Some of it will also need codes of practice. So the kind of ACAS code of practice and that kind of thing that we're used to on certain other areas like disciplinary grievance, flexible working, that kind of thing. There will be a requirement for codes of practice on certain things as well. So we'll see how quickly some of that can be done. Even those that make that initial bill, we think could take certainly months, maybe even years. And I suppose there's also this sort of convention of employment law changes generally taking place in April or October. So you might have spotted that the employment lawyers out there will usually be running employment law updates around those times because there's usually stuff to talk about. So it might be that although they're talking about 100 days, that the first changes that we see are around April 25. And again, if we had to guess, if we were being pushed on that, we think there might be changes to statutory sick pay, some of the union stuff, some of the family leave, parental leave, paternity leave stuff, as the kind of first tranche of what they're looking at. So we'll see. But that's kind of our current thinking on it. So getting into some of the areas specifically, one of the things that you will have heard lots about already, because actually the Conservatives have introduced certain things, are day one rights. So rights that workers, employees have from the point at which they join you, from day one working with you. And currently, there are certain rights that apply once you've worked for a certain time. And a few of those are on the screen. So unfair dismissal is the most obvious one, and probably the most significant one that we're going to talk about. And yeah, I think I've kind of got the most interesting one for today, I suspect, as a result of that, in terms of the impact that changes here might have. But there are also proposed changes around parental leave and/or paternity leave, which currently, again, as you can see from the slide, require someone to have worked for a certain period of time. Now, parental leave, not huge uptake of that, generally speaking, because it's unpaid. Paternity leave, obviously, more commonly taken up. But again, the suggestion is that they will apply from day one based on the limited information that we have. The other area I mentioned briefly in the intro is the statutory sick pay side of things, where employees are eligible for payment on day 4 of the sickness and have those 3 waiting days ahead of that. And the proposal when it comes to unfair dismissal is pretty radical in the sense that the suggestion is that Labour would remove the qualifying period for unfair dismissal, that 2-year qualifying service altogether. Now, I did a bit of research ahead of the session, and since 1971, the shortest that qualifying period has been is 6 months. So actually, it's a pretty significant change. I certainly remember during the time I've been practicing, it's kind of flip-flopped between 2 years and a year. And even the most recent increase from a year to 2 years had a pretty significant impact on employers, and in particular, the number of unfair dismissal claims. So the suggestion is that people would have unfair dismissal rights from day one working with you. However, the limited detail that we have, and you're going to hear that phrase quite a lot today, I suspect, suggests that there will be a role for probationary periods, so that it may be possible to dismiss people in a slightly different way during a probation period, as long as, and this is a quote from the Labour manifesto, I think, as long as fair and transparent rules and processes are followed. So quite what that means, we're not entirely sure. It may be that it's similar to the current dismissal process that you need to follow, or it might be something different. But certainly what it's going to do is put a significant focus, if this is the way that they operate it, onto probationary periods and how they're managed, what it says in people's employment contracts about them. And I think it will be very interesting to see how that plays out, both in terms of the detail that we get, because we obviously don't have that yet. But I think probationary periods often aren't managed particularly well by employers. Sometimes they're forgotten about altogether. Sometimes a manager won't apply their mind properly as to whether the person is doing well enough, and will just simply pass someone through the probation without really thinking about it. Or in fact, they are often used as a really easy way of employers dismissing people, on the basis they haven't passed probation, without really having to think too hard about the reason for that. Even though, of course, the 2-year mark in reality has always been the key one from a legal perspective, and probation period, has less of an impact. Maybe, the knock-on effect of what notice period or pay the person receives, that kind of thing, from a contractual point of view. But in reality, this will definitely bring a renewed focus on that area. From what I picked up, the reason that the Labour Party consider this important is one, it enhances employee rights. The other suggestion they were making was that it would increase productivity and lead to a likely increase in people's wages, because people would feel more able to move jobs. I suspect because they are suggesting, at least, that people are aware of the fact that they lose their employment rights if they leave a job that they've already got 2 years service in, to go to a job where they won't have. I'm not entirely convinced by that, but I guess there will be some people that do leave or do not leave a job, don't leave a job, because they would be worried about their new employer getting rid of them quickly. My concern would be that the impact of this might be more about employers being more cautious about employing people in the first place, and that actually it might stagnate the job market a bit rather than it encouraging lots of people to move around. The other thing that it absolutely will do, and I think we can probably go as far as saying that, is that it will increase the number of employment tribunal claims brought for unfair dismissal, because at the minute there will be huge numbers of people that are being dismissed and within that 2-year period and not bringing those claims because they can't. So I think we're likely to see an increase there. Laura's going to talk about employment tribunals a bit later, so I won't steal her thunder. But for anyone that has claims in the employment tribunal at the minute, you'll know that it's a slow process and taking a long time because the system's under-resourced already, and that's likely to get worse if there isn't resource given to that to the tribunal service. So that I think has pretty significant implications on that front. The other ones that we've highlighted are certain other types of leave, and again the detail is not there, and it's not particularly helpful where there is detail, because it's not even that clear whether the Labour Party are actually talking about parental leave, which is the kind of 18 weeks unpaid leave subject to certain requirements, or they're talking about paternity leave, and they seem to kind of merge the two. But essentially there is talk about those kind of parental family type leaves becoming a day one right and it being enhanced in some way. So I think that's one just to look out for. We probably can't give it any more detail than that because there isn't any. Statutory sick pay, as I mentioned, looking at the removal of those waiting days, so SSP being payable from day one of sickness absence. There is a suggestion, and I think it probably is only a suggestion in the detail that we've seen, that they might also increase statutory sick pay in terms of the amount paid, and tweak various other things to enhance it, essentially. The suggestion even that it might be increased to match the national minimum wage is one of the things that I'd seen suggested. So that obviously would be fairly significant as well. In terms of impact here, again, I can kind of see the logic behind it to improve the position for people, lower paid workers in particular, who are unwell. My concern would be that it may well have an impact on short-term intermittent absence, because I suspect that the 3-day waiting period is preventing certain people taking sick leave when they're could be at work, because they know they won't get paid. So we might see an increase in that kind of short-term intermittent absence, which is as difficult to deal with as any other absence if it's repeated. We might see, we would likely see an increase in cost for employers, because they'd have to pay more. So again, I think there could be some fairly significant knock-on effects from that change, which we just have to keep track of, I think. So I'm handing over for 0 hours contracts.
Thanks, Nick. Morning, everyone. So 0 hours contracts is something that you'll have probably seen spoken about quite a lot in the media as part of the election campaign. And in fact, Labour have been talking about it for many years now. So the media quite often say things like they're going to ban 0 hours contracts. What we think the actual proposal is, and again, as Nick was saying, we've got limited detail on certain things, but the proposal appears to be to end one-sided flexibility and ban exploitative 0 hours contracts. There's not much out there in terms of what they mean by exploitative or one-sided flexibility, but we've been doing some reading around it, and what we think that they're likely to do is look at banning clauses that provide the employer with the absolute right to say, we don't guarantee you any hours, but any hours that we do give you as an employee, you have to accept. So it's about having that equal footing for employers and employees. You'll also see that they're talking about workers being given reasonable notice of any changes in shifts or working time and proportionate compensation for cancelled shifts. Again, that's one where there's a few words in there that none of us really know what they mean by what the reasonable notice is going to be, or what proportionate compensation is likely to mean. Without the extra detail here, it is difficult to see how that will work in reality. So, for example, and I'm sure a lot of you have this situation, that the actual worker need changes greatly depending on time of year or things that are going on in the world. So it's difficult to see how that will actually happen and what will go forward with that. But it's one to be aware of, that we're likely to see something come in that means that actually we're going to need to be giving people notice, and potentially having that budget for paying people where we're cancelling at short notice. You'll see that they're also talking about a right to a contract based on 12 hours worked. So what they're essentially saying here is that there'll be a 12-week reference period for these workers, and that they'll work out, based over that 12-week reference period, what their normal working hours are, and then I'll have a right to a contract for those hours, so no longer 0 hours. The difficulty here is that we can't see what they're actually intending to do by a 12-week reference period, whether that's going to be a rolling period, whether it's going to be a fixed, it resets at this point, and then we recalculate. And obviously that could become fairly onerous on you guys as employers, particularly in recalculating it and getting that sorted. And again, will there be any special provisions in that for accounting for surges in the workforce for Christmas, for things like that? But as you'll see, they have said that nothing in their plans will prevent employers from offering fixed terms contracts to deal with things like seasonal work or fluctuations in the workforce. So that is one way that may be a way of working around that. The thing that we do see and envisage happening here is that all of these changes to the types of 0 hours contracts that you guys may operate already might lead to more employers looking at different ways of employing people. So agency staff or fixed term contracts, and different ways that they can actually keep that flexibility in the workforce. And in many ways, it could be argued that actually deviates from the intention here, that people are being changed onto different types of contracts to essentially keep the workforce and the things moving as they need to do. So you'll also see that there's a manifesto promise that they're going to make a single status of worker, which I'm going to come on to. The current status in the UK is that there's 3 categories of people providing work in the UK workforce. So we've got employee, which is essentially the first tier of that, which have the greatest statutory protections. So they've got rights to redundancy pay, flexible working requests, minimum notice periods, right to not be unfairly dismissed, family leave, maternity, paternity, etc. You've then got workers who have a limited amount of statutory rights. So you'll see a few on the slide, like minimum wage, paid holiday, protection from discrimination. And then you've got a third category, which is self-employed independent contractor, and they have very limited statutory rights. And in fact, in the Employment Tribunal, not a lot at all. So it's mainly things like health and safety and other courts. As a very quick refresh, just so that we're all on board with what I'm talking about when I'm saying what each category currently is. So an employee is an individual who works under a contract of employment. A worker is an individual who has entered into or works under A, a contract of employment, or B, any other contract where they undertake to perform personally to do the work for somebody that isn't their client or customer. So by very nature of that, all employees are also caught by the worker definition at Part A. And self-employed doesn't have a legal definition. But generally speaking means someone that's responsible for how and when they work, they invoice for their payments rather than collect wages, etc. And this is something that the worker status have been developed by case law and changes over the past, well, many years. So actually seeking to unpick this is something that's going to be quite an important and interesting one over the coming time. So as I just mentioned, Labour are talking about creating a single employment status. So what they have said that they're going to do is move towards a single status of worker to create a clear 2-tier system, so that it will distinguish between those who are in employment and those who are self-employed. So essentially merging that top 2 of worker and employee, and again keeping self-employed separate. They said that the aim is to make it clearer to individuals what legal protections they have and reduce the legal arguments around employment status. Now, some of you may have been in the unfortunate position of having employment tribunal claims where you are fighting worker status, and you'll see that it really is a very legalistic test that people go through, and it does get quite complicated. So this aim of trying to make it clearer potentially will help both employees and employers know where they stand and what is happening. I think Labour are coming at it from the point of view of preventing employers from being able to manipulate employment relationships in a particular way. And they talk about things like not being able to make their workforce in a way that attempts to cut costs or avoid or escape legal responsibilities. But again, it's probably one that for both parties, the aim is actually to just make it clearer and easier for everybody to know what is happening. At the moment, this is a very rough sketch of an idea, so as you'll see, it's unclear how this will actually work in practice. Labour have said that they're going to consult and then create a simple framework on employment relationships. They've said that they're going to essentially consult with businesses and various people across the UK about how their employers work, how their workforce sits in the employment market, what kind of things that they need to be looking at to make sure that there isn't that kind of bottleneck in the employment market, that things aren't moving and things aren't continuing. The other thing that isn't clear yet is they're talking about increased access to rights that are currently only gained by employees. So as we're saying on the other slide, things like rights from fair dismissal, as Nick's covered, statutory sick pay, again, we think might be going and changing. The thing that we're not clear about is exactly what rights they're looking at extending, how long that's going to take, and essentially what's going to happen on that front. So it's definitely one to keep an eye on, but it's probably not one that's going to be happening super quickly, because we've still got to get through that consultation period, and if they do win the election, there's that time period of having to consult and then get the legislation through. As Nick said, I'll be talking about the changes to the bringing claims to the Employment Tribunal. So one of the most significant changes that they're proposing is that, as I'm sure most of you are aware, at the moment, the time limit to bring an Employment Tribunal claim is 3 months from the date of the act complained of. You may be aware that there are a couple of limited types of claims that already have a 6-month period. So claim for equal pay or statutory redundancy payment is already at 6 months. So what Labour are proposing to do is to increase the time limit and change it so that the time limit to present claims to the Employment Tribunal for all types of claims is 6 months from the date of the act complained of. The intention is that it will provide more time for internal proceedings to be complied with, so any sort of grievance, disciplinary appeal processes, etc. And will also help support people that may struggle to put their claim in the 3 months. So they've talked about things like new mums returning from maternity leave that may need extra time to put that in, or people with a disability that is an immediate need that they need to take care of that first and then put their claim in. So as Nick was saying on his point, we do envisage that things like this is likely to increase the number of employment tribunal claims because we're giving people longer to do it. And as you already mentioned, the delays in the Employment Tribunal, and I'm sure some of you will already be aware of that, we're already seeing claims that are being listed well into the future. So I think across the team, we've all got things that are listed, I think, as far as 2026 at the moment. We've got cases that are ongoing, both in the Employment Tribunal and the Employment Appeal Tribunal, that stem back from the pandemic, redundancies and furloughs. So we're looking at 5-6 years after the actual event. So that's to bear in mind that there may be some more cases coming into the system from all the different changes we're talking about in this webinar if they do come in, and that may just add to that backlog of claims in the tribunal. So Labour have said that they'll bring employment tribunals up to standard and that they are essentially aware of the problems in the Employment Tribunal, and they've talked about moving to digitalise the tribunal system, which is something that is already happening under the current government. So whilst at the moment it's a very email and letter-based type of approach at the tribunal, there's going to be an online portal where claims are filed, responses are filed, and those sort of correspondence goes through there. So that's one of their aims, that actually continuing that rollout will help keep things moving in the tribunal system. There's no indication yet of any funding going into the tribunal system. That's not to say there won't be, we just haven't seen that there was anything being mentioned about it. And of course, that's something to have in mind, that as I'm sure a few of you are aware, that one of the most common reasons that we unfortunately have to ring or email you and say, the hearing that you've got next week's now been postponed because of lack of judicial resources, or there isn't a judge. And yes, we know that is quite an annoying phone call to take from us when you've been preparing for a tribunal. But the knock-on effect of all of this might mean that is even more prominent, that we're not going to suddenly be able to magic up judges overnight. So that's another one that we think that if they're consulting with people on that, will be something that people are heavily pushing on and saying this is something that needs to be looked at if all of these changes are to come in. I'm going to hand over to James.
Thanks, Laura. A sort of theme of today's webinar runs into my section, and it's sort of a random selection of different topics with not much of a thread other than changes. But perhaps the first major topic that I'm going to talk about isn't surprising, given this is the Labour proposals, and that is how the unions would potentially become a lot more involved with the employment scene if they were to win the election, and there would be changes to the law surrounding collective bargaining. And in a bit like the way Nick did, I'm going to do a bit of a potted history of collective bargaining, because as with politics, if the polls are right, it tends to be quite cyclical, and that's going to happen here. So those of you that have been doing this a while remember the Trade Union Act 2016, and that was the Conservative government essentially trying to make it more difficult for trade unions to initiate lawful strike action. And they did this by introducing a minimum 50% turnout requirement when balloting the strike action. Previous to this, you just needed a simple majority. So if only one person voted and he voted for strike action, or she voted for strike action, then that was a valid mandate. That would be a higher score than last night's football, 1-0, but it would be a valid mandate for industrial action. So the 50% was quite significant, because if you had a bargaining unit of 200, you needed at least 100 people to vote, and then of those, a majority in favour. And it was made even worse from the union's perspective in respect of so-called important public services. I won't really go into the detail of what those are, but you can guess, and you'd almost certainly be right. And in balance for that type of strike action, they need the support of 40% of those entitled to vote. Now, you might be saying, well, 40% is less than 50%, but if you work this through, if the bargaining unit was 100 and there were 100 people entitled to vote, you need at least 50 to vote to get to the 50% turnout requirement, and you need at least 40 to vote in favour to get to the 40% support. So that is really quite significant, and it would have hugely increased, I'm sure, the amount of effort that the union had to put in to get their sort of voters out there in much the same way. It'd be interesting to see how high turnout is in the actual general election on July 4th, because there certainly won't be a suggestion that turnout's too low for it to count. And then the other thing they did, which was again designed to help employers, was they increased the amount of notice that the union needs to give of the actual industrial action itself by doubling it from 7 days to 14 days. And that just gave employers more time to make contingencies. Because whilst there was an attempt to change the law in relation to replacing striking workers with agency staff, which went full circle in that it started out unlawful. They legislated to say that it could be done. That law was held to be unlawful and was then revoked. What you could always do was use your existing workforce to cover it, either by those people that don't go on strike or by other people doing different things. But clearly, the shorter notice you have, the more disruption there's going to be, the less chance you've got for contingency planning. So these were all employer favoured amendments in the Trade Union Act 2016. And you're going to guess what the next slide says, that the proposed change is to repeal all of that. The detail isn't great. I've just taken it to mean that they'll just scrap all the things I just said and get it back to how it was. They might go further, they might go less far. We'll see. The next point is sort of aligned to what Laura was just saying about the employment tribunal systems, and it's probably a good idea, regardless of which side of the fence you sit on this, in that they're going to propose to modernise ballots to do them electronically. I guess there'll be the same reservations about that as there probably is with the general election, in that if we thought it was secure and safe, why aren't we doing it? Why are we going to the ballot box next week? But there we are. There'll be legislation on that, and that to me makes sense. And I wonder if that will be introduced across employment law in terms of, can employers start piggybacking on that if you need to elect employee representatives, for example, because the current method is somewhat onerous if you're doing it with people putting little bits of paper into a box, and especially the modern workforce where people aren't necessarily in, electronic solutions have got to be the way forward. The third one's an interesting one. It's fairly straightforward, that they're proposing to introduce an obligation to notify employees of their right to join a union, sort of a positive obligation to make them aware. And the suggestion is that would be in statements of employment particulars. So I'm guessing that they'll do what every government has done since 1996, seemingly, and bolt more things into Section 1 of the Employment Rights Act that you have to say. I presume it would just be a standard phrase, you can join the union or something to that effect. Not sure how useful that would be. The other thing that's quite interesting on that one is you're then supposed to remind them of this fact on a regular basis. I don't know whether that's, you're supposed to sort of every year the employer is supposed to put up a leaflet going, remember you can join the union. Seems a slightly interesting idea, but will be interesting to see how they legislate that. And then the fourth one might certainly scare some employers, and they want to introduce rights to create rights for trade unions to access workplaces in a regulated and responsible manner. And I don't think they're trying to do anything that's sort of sneaky or underhand here. I think it's fairly open that they're trying to allow unions to have the ability to market directly to the consumer, in effect. And they don't want employers to be able to stop that. And the only reason I can see why they want to do that, and it does make sense from a Labour/union perspective, is that they want to encourage people to join unions, and they want to increase the amount of collective bargaining or union involvement there is in the workplace. And what better way to do that than to allow them into the workplace? Because one of the things I've been reading, and I think this is got to be right, is that the modern workplace is perhaps different to when trade unions were last more prevalent across employers, and perhaps they need to change their value proposition in order to attract new members. Because my experience, and I think probably yours, of employees is that they can be quite demanding. And so in certain industries, they might be saying to the union, well, what are you going to do for us for our money? So maybe that could be an interesting development if it happens, as to how that interaction between employees and unions are, and how receptive employees are to the involvement of unions in workplaces where that hasn't previously been the case. I suspect it will be less relevant really for currently unionized workplaces, because there's probably already an in there. So that's an interesting one. A few more parts about collective bargaining is a key piece of the Labour proposal. The first is allow employees to raise collective grievances to ACAS. That isn't a typo. I do mean to ACAS. So as you all know, employees are currently just supposed to raise grievances with their employer. And certainly from my experience, it's not uncommon for employees to raise collective grievances. And I've known employers have collective grievance procedures, and even where they don't. The sensible thing to do if you did receive a grievance from a number of people is just agree with those who've brought it a sensible way forward. The involvement of ACAS seems to be interesting. It partly goes back to Laura's point about, are ACAS going to have greater resources in order to be able to help with this sort of stuff? But the other part of this proposal I thought was interesting is that there's a suggestion that there might be a right for employees to obtain union representation as part of a collective grievance, even where the employees aren't part of a union or the workplace isn't unionized. And I guess that's with a view to try and resolve the collective grievance more efficiently if the union's involved. And the details on this proposal are pretty thin. That's about as far as I can go. Second bullet point, statutory union recognition. You'll probably be pleased to hear I don't propose to talk about how you currently do that, other than to say that it's quite tricky, and the unions would say it's too difficult, and employers would probably say it's not difficult enough. And one thing that happens with it in practice is if there is likely to be sufficient support for statutory recognition, in some respects, encourages employers to just voluntarily agree with the idea of union recognition and come to their own collective agreement, because the statutory recognition process and statutory recognition is potentially more onerous and procedural than just agreeing something with the union that you can at least thrash out and be happy with. But the process, the proposal is simply to make it a lower threshold. So at the moment, broadly speaking, I'm oversimplifying, the union needs to show that broadly 50% of the workers are likely to support union recognition before they can get things off the ground. The proposal is to lower that, and I suspect that the approach of the Labour government would be, or the aim would be similar to how I just sort of articulated, that by making statutory recognition easier, it would encourage voluntary recognition to avoid statutory recognition, which achieves the aim of increased union involvement, more collective bargaining. Two further things about collective bargaining and union involvement. Labour are proposing to introduce a so-called fair pay agreement in adult social care. Again, the interesting thing about that is funding. The social care sector obviously is stripped of funding, so how are they going to afford whatever so-called fair pay is, and how's that going to be negotiated? I'm not sure. But that's almost looks as if it's being done as a sort of pilot proposal, because you might have seen in some of the earlier iterations of Labour's sort of documents, promises, election pledges, is that they were talking about sectoral collective bargaining across industries. It almost seems they're saying that's to follow, and I do wonder whether they're going to do this fair pay agreement in adult social care, see if it works, assess its benefit, and then decide whether and how to roll it across to other sectors. So it might be one that's beneficial for those people who aren't in adult social care, because you won't be the guinea pigs. Now a complete change of direction, but just to pick up on one of the things, I think Nick mentioned it earlier, is featuring in the Labour documentation, fire and rehire. A brief reminder of the current position. Employers can seek to, in effect, enforce contractual variations by dismissing employees and offering re-engagement where the variation that the employer is seeking to agree cannot be agreed. So broadly speaking, the process would be employer says to employee, we want to change this term with your contract. Do you agree? Will it assume they say no? Otherwise, happy days if they agree. If they say no, then the current sort of method would be the employer enters into a process of consultation with the employee, not that dissimilar from redundancy consultation, with a view to obtaining that agreement. And if after a process of consultation there's a stalemate, the employer has the option at the end of serving the employee notice of termination on their current terms and offering them re-engagement on the new terms that they decided not to agree. That leaves the employee with two choices. One is they work their notice and leave, and the other is that they just accept the re-engagement and they carry on. One of the things that some people forget when they talk about dismissal re-engagement from an employee perspective and looking at the sort of harshness of the law is that the employee does have that choice, and even if they accept the new terms after they've been dismissed and offered re-engagement, or if they decide to walk away, in either scenario they can challenge the fairness of that dismissal in the employment tribunal. So that's one thing that employers are wary of. And the other is simply the loss of talent. You might think, well, we'll just dismiss and re-engage, but if everyone leaves because they think it's unfair, then employers have potentially shot themselves in the foot. So I think sometimes it's overstated how often employers do this, because employers I know are sort of mindful of the risks, the two risks. One is losing people broadly, and the other is claims. But having said that, if you do get to the scenario where you do dismiss and re-engage and there is an unfair dismissal claim, then it's not especially difficult, depending on the circumstances, to defend that claim. The fair reason that the employer relies on, assuming that the employee has their unfair dismissal rights, which, as Laura said, or Nick, sorry, said, may be moot in the future, as everyone will from day one, is some other substantial reason. Essentially, the reason they've been dismissed is because they didn't agree to accept the contractual change. Now, the case law has looked into what that means in the context of this scenario and has said that the employer needs to have a sound, good business reason. So that the key distinction that the case law has drawn is that doesn't mean that if they didn't do it, that the employer would be potentially at risk of significant financial difficulties or going under. It merely needs to be a sound, good business reason, and that's as broad as it sounds. And there could be a number of reasons in any given case. And then once they've established that fair reason, they just need to establish that terminating the workers' contract for that reason was reasonable, which is a similar assessment as you would have in any other type of unfair dismissal claim, where you look at all the circumstances, but relevant factors would be the motives of the employer for change, the reasons the employee didn't want to accept it, how much warning the employees were given, whether alternatives were considered, whether there was genuine and meaningful consultation, and what the impact on employees would be. And quite a critical one is whether people agreed. If you tried to agree the change with 100 people and 98 agreed and one brought a claim, you'd have quite a good argument. The tribunal will say it can't have been that unreasonable. 98 of them agreed. They didn't bring a claim. So that's that. And from past seminars or from your general keeping up to date on these things, you'll probably be aware that a statutory code on dismissal and re-engagement was brought in. That doesn't go much further than really writing down some learning points from the case law and providing employers almost with a framework as to what to do if they're going through a dismissal re-engagement process in order to try not to fall foul of unfair dismissal. So what are the proposed changes? Well, you've probably guessed, make it harder to do that. And it goes against the current case law, essentially the first bullet point. I'm not exactly sure how they do this, whether they change the legislation or whether they bring in a new code of practice that would have to be followed. But essentially only allow businesses to dismiss and re-engage where it's necessary for the business to remain viable and there is no alternative. So a much higher bar in establishing fairness, in a sense. And the Labour proposal is to replace the code with something much more strengthened in some way. Presumably, my guess is setting out what might constitute necessary for a business to remain viable, because on the face of it that sounds quite rare, which would almost make this code little used, because employers would be so scared to do it because they don't think they'd be able to fall within the exception. This is one of those changes which I can envisage having a curious counterproductive impact for employees, in that if you can't dismiss and re-engage to reduce terms, unless they're changing the law on redundancy, it might be simpler to just reduce costs by making people redundant. And that is probably worse for employees than perhaps reducing their pay slightly or taking away a certain benefit. But there we are. We'll see if that turns out to be a sort of correct prediction if this happens. And then I put at the end of the slide the P&O irony, because those of you that have been following this fire and rehire jargon for a while might remember that it all really derived from P&O dismissing a lot of people as redundant and then replacing them with agency workers. And everyone got very upset about that, and perhaps rightly so, because what P&O did was breach their duty to consult under the Trade Union Labour Relations Act and offer large settlements, I understood from the press, to those that had been affected. But what they weren't doing was offering the employees new terms. They were saying, if you want to go and sign up with the agency, you could potentially get your job back on lower pay. But that's not dismissal and re-engagement. So a lot of these changes were designed to stop happening something that isn't this. So whether you agree or disagree, it does seem slightly strange circus of how we got there, because what people were upset about was something that's already unlawful, which you can already bring claims for, and which anyone who sued P&O almost certainly would have won, because they didn't consult for the requisite 100-day period under the Trade Union Labour Relations Act. And they did what employers do from time to time, is they just decided that they were going to pay out, in effect, as my understanding, rather than worry about complying with their obligations. And whether you sort of think that's right or wrong, the law's there to protect the workers in that scenario by compensating them, and that's what it would have done. Equality proposals. These are sort of more nuanced and probably less, I say, significant. With smaller changes, significance, your choice as to how significant you think anything is. The first is continuing a general trend about reporting requirements. And there's a proposal to require employers with more than 250 staff to publish ethnicity and disability pay gaps. The commentary I've read suggested that they think that more consultation is needed as to what this is actually going to entail to make it meaningful, because there's a concern that I share, is that 250 is a relatively small number of staff. If within that, say, especially on disability pay, say you've got 2 or 3 people who are disabled out of 250, then it's highly unlikely that your statistics are going to be in any way statistically meaningful. And being someone who is a bit of a maths geek, I did maths A-level. If you were doing modelling statistical significance, you need a bigger sample size. So I'm not sure whether this is going to reduce much, but the thinking behind it, which most people agree with, is to try and reduce discrimination equality in the workforce. And so I think the challenge for Labour, if they want to do this and via the consultation, is working out how the reporting requirements can provide employers with something that's meaningful to allow them to actually solve the problem that they're identifying. And I think that's extremely tricky, and I'm glad that I'm not involved in trying to solve that problem, because it to me seems a very difficult one, if well-intentioned. The next one, I think, is another well-intentioned change that I personally think is somewhat pointless, and that's to introduce the right to claim for dual discrimination. Those of you who remembers the seminars that were happening, and I remember doing them back in 2010 when the Equality Act came in, remembers people like me saying, and there's going to be a new thing called dual discrimination. And it was in the legislation, but from memory, I don't think it ever got brought into force. And I think the reason why was because I'm certainly struggling to conceive of a situation where there can ever be a dual discrimination claim that can succeed in a scenario where a normal discrimination claim wouldn't succeed. So one of the examples I've seen given, and it relates back to the telly, is there was a view that older female newsreaders were being treated badly, as opposed to younger female newsreaders or older male newsreaders or other television presenters. And that might have been right, and that might have been wrong, and that could have been challenged in the employment tribunals. But the reason I don't think dual discrimination is particularly necessary is because of the way direct discrimination currently works. So direct discrimination says it's discriminatory for an employer to treat an employee less favourably because of a protected characteristic. Now, if we just look at one protected characteristic, it's very rare that it's so overtly discriminatory what the employer does. And the case law has said that the protected characteristic only needs to be part of the reason for the treatment in question. So if the newsreader is saying it's partly because I'm female, because if you look at my male comparators, they're here, and it's partly because of my age, because my younger female comparators are here, then to me that's just an example of both sex and age discrimination, because part of the reason for the treatment they've suffered is 2 different characteristics. So I'm not sure what dual discrimination really adds, but nonetheless, if it doesn't add anything, you could argue it doesn't detract from anything. So there we are. So I'd be interested to see if that comes in and whether it makes any difference, because to me, and experience in the tribunal that a lot of you probably had, is that employees usually hedge their bets by arguing things in the alternative. So I can just see someone now saying it's 2 characteristics, either individually or combined, and you're just adding a 3rd claim when there was previously 2. I don't think anyone's going to hang their hat on dual discrimination alone and live or die by that. They'll hedge their bets in various different ways and just make claims more complicated, but there we are. And the 3rd point, equal pay law to be extended to cover race and disability. I think this is another suggestion that is more of a vote winner for members of the public than employment lawyers, because employment lawyers know that equal pay law is really complicated and slow, and is part of the reason, you know, I'm not blaming equal pay law, but part of the reason why the tribunal system is backed up. Clearly they're backed up because of volume of work, but equal pay claims do stay stuck in the system for longer, and that's because there's a different process for them, and the method of obtaining comparators can be quite complicated and often needs expert evidence. And the reason I think that a lot of people aren't that positive in the employment world about equal pay law being extended to race and disability is a similar argument as the dual discrimination argument. And it's simply not needed, because what sort of is implied by extending equal pay law to cover race and disability is this implication that it is in some way lawful to pay someone less because they are of a certain race or because they are disabled, which it absolutely currently isn't. And that could be brought as a standard race or disability discrimination claim. And the advantage of that, or what the advantage currently, is that you could rely on hypothetical comparators in such a claim, whereas an equal pay claim, you have to rely on real comparators. The other difficulty I can envisage in equal pay law being extended is the sort of premise of the equal pay legislation dates back to the 1970s, and a lot of the comparisons in some of the cases are to so-called men's jobs and women's jobs, the bin men versus the dinner ladies. And I think it's going to be a lot harder to construct that type of comparison for race and disability in particular. And it might lead to lots of irritating preliminary hearings before an employment tribunal where lawyers are being very picky about who are you actually comparing yourself to? What is the group of employees? And that will all just take time. And whether or not it would have been easier to just go under the current rules when you're arguing race or disability discrimination, where you can rely on hypothetical comparators, I don't know. But we shall see how that develops. If it develops, that might be one that is subject to further consultation, especially in employment law experts across the political divide. And they might think that perhaps that's going to be more trouble than it's worth in terms of it might not introduce more rights and might cause problems elsewhere in an already creaking system. Speaking of creaking systems, this is a whole new system to enforce rights that they're proposing, the single enforcement body. And that would be a state enforcement separate from the employment tribunals, where this body would look to enforce some of the more simple aspects of employment law: working time, holidays pay, sick pay, discrimination practice against migrant workers. So it would be more looking at mass issues, I would imagine, rather than one-off cases. And this is one of those ideas that has been bandied around in different forms over the years and seems to have a lot of sort of political support. But to me, it's just a case of, if they are going to do it, how much money are they going to put behind it? Because an enforcement body is only going to be as good as the resources they have to enforce. So that will be the interesting on that, to see if it gets off the ground, how much power it has in terms of its spending to actually enforce. And then the final point I want to talk about today, thresholds for redundancy consultation, is, as far as I could see, this one was sort of snuck into one of the more recent Labour documents. It wasn't in the original proposals, but it sort of seemed to have worked its way into the manifesto. And that's a proposal to extend the to expand the obligation on employers to consult with elected representatives. So just a quick reminder, Section 188 of the Trade Union Labour Relations Consolidation Act requires employers to consult with appropriate representatives, so either the trade union or elected representatives, depending on whether there's a trade union, where they propose to dismiss as redundant 20 or more employees at an establishment within a 90-day period. As I sort of emphasised when I was saying that, trying to say it carefully not to get it wrong, is this business of an establishment. And that is the part of the legislation that I assume from the proposals they'd be seeking to change from an establishment to the business as a whole. Now, on the face of it, you might think, well, that doesn't sound particularly different. But those of you who've been doing this a long time might remember the case of Usdaw, the union, and Ethel Austin Limited, more commonly known as the Woolworths case. And that case was an argument as to whether, in effect, the individual Woolworths shops that were closing, whether they were establishments or whether the whole of Woolworths across the country was the establishment. And so what Woolworths did was, in the stores where they were proposing to dismiss as redundant 20 or fewer than 20 people, they didn't comply with the duty to consult, but in the bigger ones they did. And what the Employment Appeal Tribunal said, somewhat surprisingly at the time, was that the establishment was the whole of Woolworths, and they should have aggregated the number of employees who were being or who were proposed to be dismissed in the 90-day period, and to consult with all of them, or in respect of all those redundancies. And so the position was confusing for a few years. That case eventually made it to the Court of Appeal, and the resolution was that it went back to the position which was whatever I thought it was before, which was in a situation like a retail shop that runs independently, that is the establishment, not the business as a whole. But what you had to do when there was that period of confusion, or what employers did, thinking that Woolworths and the EAT might hold up, was you had to essentially aggregate across your business and keep a running total. And the reason that I'll self-confess to not have being a fan of this at the time was where you were advising a business that was very separated or diverse. You could have funny scenarios where they had two factories, one in Newcastle and one in Bristol, that made completely different things. The one in Newcastle was closing or proposing to dismiss as redundant 100 odd people, so the legislation was triggered. And down in Bristol, you might have just been dismissing one standalone role, but because it was happening in the same 90-day window, you had a duty to consult with representatives in respect of the one redundancy in Bristol. And that seems impractical. And also the consultation itself for employees is a bit weird, because clearly the thing you're consulting on and the reasons are completely independent of one another. They're in completely different parts of the country, and you've got a very strange scenario. So it will be interesting to see whether or not this proposal, where it's across a business, will contain a bit more nuance than that. So it's a bit more practical, because whilst from a basic level, I can understand why a Labour government might want to increase the need to consult with representatives. Surely they would also want that to be a meaningful exercise and not just a sort of slightly strange box ticking exercise or an onerous exercise where, as I said, you're consulting in respect of two completely independent proposals at the same time, and one of them only affects one person. It just seems a bit strange. So it'll be interesting to see if that is fleshed out, and that we're not left in the slightly unsatisfactory position we were before the Court of Appeal resolved the Usdaw Ethanol Austin case, to get it back to the current position where the establishment test applies. So that's the end of that slightly bitty section. That leaves us with the opportunity for you to ask questions. The only thing I'll say is, if it's about the detail, we may not know the answers, but you can ask.
Thanks, James. Yeah, so feel free, guys, to pop any questions in the chat, or if you're really brave, you may be able to unmute and say hi and let's have a question. Or in fact, any feedback on any of the proposals in terms of the implication. One of the useful things I think from these sessions is for us all to kind of share our thoughts as to whether something's completely bonkers, or whether we think it's a good idea, or whether there are implications that any of us might have missed if those changes took place. Certainly in the team, we're discussing a lot of that stuff pretty regularly in terms of how might this work and what implications might there be, and what might we see, you know, as a kind of unintended consequence of some of these things. No questions immediately. Oh, Gareth's got his hand up.
His hand up, yeah, Gareth.
I was going to just say, hi everyone, I'm Gareth. I've been in HR for way too long. And it's really around the requirement of collective consultation versus individual consultation. So where collective consultation, in my experience, works really well is where you do have trade unions, and where it's really difficult to actually have any meaningful consultation at collective level is when you're working in an organisation that hasn't got trade unions and nobody wants to do that, and you're already doing individual consultation anyway. And it's always struck me as a completely fatuous piece of law that doesn't really assist anybody in doing anything, especially if you're doing individual consultation with your affected employees. So I'm just interested to see how the proposals to do more collective consultation will manifest themselves, where, especially if you've only got a small business, and as James alluded to earlier, where you've got different divisions in a business and certainly bits that aren't affected, why would you be doing collective consultation across the whole organisation when people aren't going to be affected remotely? It just is a bit meaningless, certainly based on my way too many experiences, I guess.
Yeah, I agree, Gareth. I think where there's recognised unions and they're involved day to day, the consultation works and everyone's used to it, and it helps potentially if both sides are being reasonable. But yeah, I think sometimes it can be a bit artificial where you have to start involving. So sometimes collective consultation where there isn't union involvement, or it can be a bit artificial. So I guess it's that without being political, I think the idea of some of the changes are to increase union involvement.
Yeah.
And so I think maybe that's part of that, if there's an aim that unions are becoming more involved, one of the ways to do that is to require them to be involved in more ways. So I think it's sort of a concerted approach, whether it'll work. Yeah, we'll have to see.
I think that's right. Claire, thanks for your question. So Claire says, do you think there's likely to be consultation with businesses over the changes to unfair dismissal? James has been straight on it, and I agree with him. So we don't think that there will be consultation on the changes to unfair dismissal. Certainly not changing the service requirement. We think, in theory, we think they could just change that pretty easily. Because there's the power to do that already. The thing that will be most interesting, I think, and probably will take more time and might involve some consultation, is how the probation period bit will work. So there are some commentators talking about the fact that that will be the complicated piece because it's new and they'll want to get that right, and that might take a bit more time, and they may be interested in people's views on that side of things. But in terms of the change to the service requirement itself, the qualifying period, we think that's highly likely just to be changed, with pretty significant implications, we suspect. Any other questions?
Yeah, come on in. Yeah.
I don't know whether I've got Italian.
Just muted Gareth there. There we go.
No, I think the question might be coming from someone with Gareth. Yeah.
Oh, I don't know. No, I'm not sure about that. Alison, though, has a question. The use of within 100 days, what do you think the prospect that it will be much sooner? I think most people are thinking that it won't be within 100 days, and therefore anything sooner is unlikely. But who knows? I guess there are certain things that will take legislation to be put in force, and that does take time. Alison saying our CEO is thinking rush legislation. I guess it's possible. Yeah. I think we have seen situations previously where Conservative government have kind of forced things through. And the rest of us have thought, hold on a minute, we don't think that the detail is there, and we don't know the implications of this and how it's going to go. So it's possible, but I suspect the 100 days is probably optimistic. James, what do you think?
I think you're right, Nick. I think there's some low-hanging fruit on things where they can just repeal stuff, or, as you say, the part of the Employment Rights Act that says it's a 2-year qualifying period. You can just tinker around with that by amendment. So that's easy to do. So I think what they'll do, probably, without meaning to sound too cynical about politics, is they'll do some stuff within 100 days that's actually achievable, so they can say they did stuff within 100 days. And some of the more complicated stuff, I mean, Laura had the unenviable job of explaining what on earth a single state of employment will be. Yes. I mean, everyone's been trying to work that out for about 10 years. So how they're going to do that within 100 days?
Yeah. Claire says, how about EU-derived legislation? This is one for you, James. Where do you think Labour might go with the grand repeal?
Well, that links back to the rushed, Alison's comment about rushed legislation. I think the legislation they brought in to change the way holiday pay works, the changes to the working time regulations that came into force on 1st of Jan and are now affecting people if their holiday year started in April and will affect everyone from next year, are an example of rushed legislation that isn't very good, and they had to rush it because of the point Claire makes about the EU bonfire. I think they'll leave it alone because of the politics of it, in that they'll just bring in domestic legislation and they'll sort of not mention it because mentioning Europe seems to be a political no-no on all sides now. And so I think they'll just do employment legislation and not mention whether it derives from Europe or otherwise, because that's the irony of unfair dismissals, a purely British construct that we invented, and is probably the most generous right there is.
Yep.
Yeah.
Amy, thanks for the feedback. Says brilliant summary of potential impacts. Thank you. Sorry if I missed it, but did you talk about the right to switch off and what that might mean? You didn't miss it, Amy. I don't think we did talk about it, and there probably are a few other little bits and pieces that we didn't include on the basis that we didn't think we'd have time. But you're right, that is being proposed. I think that in a similar way to France, I think at least, and a number of other countries actually, there may be legislation which the broad principle is that employers won't be able to contact or email, I think is often focused on, isn't it? Their employees after certain working hours, subject to various caveats around certain services, I suspect public services and that kind of thing. And again, I suspect part of the reason we didn't include it is there's so little detail on that that it's almost meaningless to talk about. But you're right. Again, despite the lack of detail, the significance of that, if it were to be something that they try and legislate for, would be pretty it would be pretty significant. But we'll see. I suspect that's probably in a pile to come later and further down the tracks. If they manage to, as James say, pick off some of the lower hanging fruit and then achieve some stuff quickly. Any final questions? Thanks for those that did message those through or unmute and share them with us. Fine. If there are any, do feel free to pop them in. Oh, here we go. Jane, what does Jane say? It's actually disappeared off my screen.
Oh, she's just saying
that
we must have read a lot. Yes, we did read a lot, and the thing is, the manifesto had things in it that the previous proposal didn't. So it was working out what survived, what came in, what they meant by certain bits and not other bits. So I suppose that's something to bear in mind in terms of what's going to happen. Without saying that politicians don't follow their manifestos, I suspect some bits will sort of drift away, whereas other bits might remain front and center, because certainly some of it's a lot harder to do, regardless of whether you think it's a good or a bad idea. Just difficult.
Yeah, and Jane knows as well. We also needed a gin, and we also like a gin, especially Laura. There we go. So closing slides. For those that were on at the very beginning, will have seen these already. So it's a quick recap, and then we will let you go. So we're doing a free employment contract review, ensuring that your contracts are up to speed and legally compliant. There were some changes prior to COVID that has meant that a number of employers have kind of missed this. In fact, I've had a couple of messages already from our attendees saying, please, can you do this for us? So that's great, and we'll sort those. But if that would be of interest, then do let us know. We're also doing lots of training at the minute, lots of in-person training in particular, working with HR teams and teams of managers, upskilling them on a whole range of different topics. But we're certainly seeing a real investment from employers in terms of their culture and employer brand and all that good stuff, just getting their people up to speed for dealing with these kinds of issues, disciplinary grievance investigations, ED&I, all that kind of stuff, with a real focus on ensuring that they manage legal risk, manage PR risk, increasingly the case too, and keep the employer in a good place on all of those fronts. If you're in the East Midlands, do check out the East Midlands HR network. There should be a link to that earlier on in the chat, and also the podcast. My monitor just switched off, so hopefully you can still hear us. I'm just going to go for it. But the podcast we have with Dawn at Fuller's is a great episode. It's the HRD Talks, and hopefully you can check that out, and we would love some feedback on that. So I think that's pretty much it. Thank you, everybody, for joining us, and we'll see you next time. Do let us know if there are any topics for the next webinar that you'd like to see. We're still working on that. We've got a date, and the invite will be coming out shortly. But we look forward to seeing you then. Thanks, everyone.